take this across to the lawyers who are concerned with this case. Advocate Shobha Gupta is Bilkis Bano's lawyer who is joining us. And Rishi Malhotra is also the lawyer of the convicts in this case. Shobhaji, the court also raised a question today, and it's a technical question. Is remission a problem? You have argued that this remission is bad in law. But it is also a reality that this remission is something that is allowed as per policy, and the court itself had said that it can be considered under 1992 policy. So I want to understand from you, how will you be arguing this case further to prove that this remission has been bad in law?
Today I have not argued. These are not my petitions which were listed or taken up on the board. These were two public interest litigations. We call them PILs.
Right.
Those petitions were filed. Those were, initial observations came from the court where the court was saying, so what was so wrong about? Basically, I believe they are saying what was so wrong about our order of 13th of May. And that we had simply asked for, and this is what Justice Rastogi said precisely, and Justice Vikramnath caveated. So to say that we had only asked the government to look into the application and consider the application, which is rightly so one can ask for. Yes, I wish the papers were there before the court and court were knowing in which order they are passing this order. But assume, irrespective of the facts of the case, the court would have decided to ask the government to please consider, because of your policy, they are entitled to make an application and you are duty bound to look into the application. So far, so good. Nobody is coming in the way of a remission policy, which allows and which is criminal law, criminal procedure code allows.
Right.
That you can ask for remissions. The government should have remission policies and the government should look into, and if they find the person is entitled for considerations, they should be allowed to come out prematurely. They can be allowed to. The major grievance, I'm not saying I'm giving up my challenge to the order of 13th of May passed by Supreme Court. Not at all.
Okay.
But if we have to today talk on the face of that order and the direction passed therein, our precise objection to the remission order is, given the facts of this case, given the egregious nature of the crime committed in this case, which is not merely an allegation but established in 3 courts.
Right.
When Supreme Court was dismissing the special petitions filed by the accused, they made an observation that you have been let go very easily. And please do not force us to make more observations beyond this, but this is not a case to interfere. Normally, generally, when you come in appeal in Supreme Court challenging conviction, they do sit and consider the matter to see whether some mistake may not have committed. Every accused has a right to go for an appeal. Here in this case, on the first date, the special petitions were dismissed. That's not something so normal. And 2, on face of the fact that this nature of crime, why do I keep repeating? Like we all know now the facts of the case when it comes to what was the crime.
Yes.
But does it lie in somebody's mouth to say, no, that was not crime enough, or that was not one of the rarest of the rare case? Then if not death, but this death penalty was not granted in this one, or not sentenced in this case, that was already, a clemency shown to them for whatever good or bad reason. But a case of this nature, crime of this nature, can you as competent authority allow the accused and convicts of this crime come early out on road to live like another citizen? Is it punishment enough? For me, remission is not only were they entitled for remission. The fact that was this punishment enough for the crime they had committed? 14 lives they had taken.
Okay, so you are saying that essentially this is not a matter of whether they were entitled to remission, whether even under 1992 policy they can apply for that remission. But the state government or the panel that decided on it should have shown greater or better judgment before they allowed the remission. In legal terms, you are not making an objection. Am I right?
I'm so sorry. I'm so sorry. You got me wrong.
Okay.
I am not for a moment saying we are not raising that challenge.
Okay.
When you argue, when you buttress one argument, that doesn't mean you have given up the rest.
So, ma'am, how are you saying that this is bad in law? That's what I wanted to understand from you. What will your challenge be?
My friend, today, none of us have the remission order in hand. Okay? Now, remission order, when it is there, we can examine the circumstances which have prevailed over the authorities to come to a decision. Yes, for us, it is a befitting case where, despite the crime committed by them, despite the nature of the crime, despite the number of lives they have taken, the number of rapes they have committed, on each person, multiple rapes by multiple people. A 3-year-old child was smashed to death. If these case, after considering, one can say, oh yes, still it is a case for remission,
then it's a problem.
We have to see that whether that was the case.
Yeah.
Today we are saying, how come remission? Today we do not have the order.
Right.
So we cannot say the reasons given were not correct. We are saying, how come even on facts of these cases a remission come?
Okay, fair enough. Fair enough. I do want to point out to our viewers that the other problem in this case is that it was decided under 1992 remission policy, which does not have any exceptions or barring. The new remission policy in 2014 had exceptions that in heinous cases of rape and murder and gang rapes, those remission cases must not be considered, and it is also a stricter remission case policy where it has to go case by case. You have to go to the judge also of the judge who presided over the case and convict